Hello, everyone, and welcome to this special legal update on casual workers. My name is Nihal Samara. I'm the General Counsel and Legal Director here at the law firm Kaizen Synergy. We operate the Gemba360 compliance system that your agency uses. I'd like to welcome you all to this special legal update that we are running that came out of the recent federal court decision. It does seem to impact on the contractual relationships and sets a new precedent for agencies that employ and use a casual workforce. It cuts across, which we will have a look at, the contractual obligations that you might have in place, and also redefines what a firm commitment, and we'll see what that terminology uses, what that means for your agency as well. So what we're going to do to this morning is to look at really what is the issue here. Why has it caused such a storm in the media over the last few days, amongst us also having to deal with the public health challenge of the coronavirus amongst all of this as well too. We're going to look at what are the legal rules about the casual workers and how that's defined in the Fair Work Act and whether that's sort of relevant here and how that looks at it. We'll go through that. We're also going to look at what did the federal court actually say that has caused such a storm and why is this important. Equally, we're going to look at how does this apply to your agency and what are some of the things that you really should look at to address this, and also to look at what your obligations may well be. We're also going to look at, well, what should you do around this? And as always, at the end of this session, we will open up the phone lines and computer lines, and stay online to answer any questions that you have. As always, these sessions are recorded all the way up to the Q&A part of the webinar. We do stop the recording just before then, as many of you are aware. And also we will be circulating out these PowerPoint slides, the webinar, and other resources as well too this afternoon. These webinars will also be loaded into your Gemba360 College e-learning library, and you can freely access these at a later period of time as well. As always, we'd like to pay our respects to the elders past and present upon the lands on which we all meet. While this session is being run by webinar, we do pay our respects to the traditional owners from where you join us today. So let's look at first of all, let's look at what is the issue here. First of all, the federal court has confirmed that long-term casual workers can dispute their status and seek payments for entitlements such as annual leave. Now, this is quite a significant position because, quite simply, and I'm summarizing it down, most companies that employ casual workers, in inverted commas, they are with the expectation that you're going to pay them a higher rate or a higher hourly rate, and that there aren't any additional entitlements that they would seek as part of that arrangement. What the federal court has actually identified is really a fundamental flaw in the Australian employment law itself, and I'll come to what that actually is. There is talk, though, that the Minister for Industrial Relations will consider legislation to actually address these concerns. So if that's the case, then what we might see coming out of this is that the Minister will actually seek a legislative change to actually address these concerns. That said, we have a window that your agency needs to look at in terms of where the federal court and what they've said and where and when new legislation comes in. So there is this, I'm going to say, this gap, this compliance gap at the moment that your agency is in. And it's not just your agency, it's all other companies that employ casual workforce that are affected by this itself. The most likely response is that there will be a changing on how casual work is defined in the Fair Work Act. But as I said, until that time, what are some of the steps that your agency can do to mitigate this? We'll actually cover in this brief session, and equally look at, well, what is the impact that it has at the moment, and give you some information around why is this so important, and what are we looking at here. So what are the legal rules about casual workers? Well, under Fair Work, and this is an extract directly from the Fair Work website as of today as well, is that casual employees are there that when they do not have a firm commitment in advance from an employer about how long they will be employed for, or the days or hours they will work. A casual employee also does not commit to all work an employee might offer. For example, an employee who works to a roster that could change each week and refuse or swap shifts is defined as casual. So with that, as Fair Work points out, a casual employee has no guaranteed of work hours, usually works irregular hours, doesn't get paid sick or annual leave, and can end employment without notice unless notice is required by a registered agreement, award, or an employment contract. So really, when we look at the legal framework under the Fair Work Act and Fair Work itself, then this is really the framework that we're all working under at the moment around that. So a casual employee is a person that meets these sort of four requirements, and more than likely yourselves would have some sort of contractual agreement that covers these points off in a broad context. So the next part is really, when we look at this, what did the federal court say that has caused such a storm, and why is this actually so important? Now, when we look at the media, it does tend to summarize this down, but we are just going to have a look at the case just to provide some background for yourselves, and so that you understand really why the court made the decision and what it actually involved as well too. Because once we do that, we can then look at, well, what are some of the broad context applications it has for your agency. So on the 20th of May, the full Federal Court of Australia handed down a decision about casual employment. And this was under the case of WorkPack Proprietary Limited against Rosado. And we'll actually circulate these rounds with this webinar as part of the resources as well too, and send you a copy of that as well. Now, why this decision by the Federal Court is important is for this particular slide specifically. In Australia, just for yourselves that aren't aware of how this works, is that Parliament effectively will make the law. So we see that with the minister that will make has the power to change the law around this and provide the legislation before Parliament. And that's where we're sitting with the direction around Minister Porter looking at what has come up. What happens though is that what we say is the courts, or the judiciary, in this case the Federal Court, will actually have or has the power to make judgments on the law that Parliament makes. Now, so this is actually why it's caused such a storm, because Parliament has made the laws about casual workers, and effectively the executive government puts that law into action. But it's actually the court, and in this case the Federal Court, that has made a judgment on the law of how it's actually applied. And this specifically applies to casual workers. So it's for this reason that we need to look at what the court actually said about the law that Parliament made. Now, as part of that, I will mention, just going back to this slide, here that as part of this, what you will often see, and we're seeing this at the moment, is that when the court, like the federal court, has made a decision on the law itself, Parliament, if they wanted to get the outcome that they have, will actually try and discuss this at Parliament, change the law to make an adjustment to what the court has actually said. And that's the position we're in. So we're in this kind of grey zone at the moment. Now, what was this federal case about? In this case, an employer paid an employee at a flat hourly rate in accordance with the contract of employment. So they paid them a flat hourly rate in alignment with the contract of employment. And this is something that your agencies, no doubt, would do for casual workers. The employer included a casual loading and claimed that if the federal court found that the employee was not a casual employee under Fair Work, or in this case, a casual field team member as there was, it was entitled to the casual loading shouldn't have actually been given to the employee and really should be sought short back payment from the employee around. So idea is that, hang on, you've got this casual work, that person that's claimed that they're a casual worker, but they've been given a flat hourly rate, which they've done under the contract of employment. They've actually given them a loading on top of that, which no doubt we have with casual workers. They are paid a higher rate. But if they're now saying that they got this extra payment, then surely they have been unjustly enriched or payments received by them. And if that's the case, then it's actually the employee that really, the employer should be able to take this money back or transfer it to the leave loading itself. So what has happened in this case is that 3 justices, Justice Broomberg, White and Whelan, oversaw this case. And what happened was that Mr. Rosato, who was the employee of a company called WorkPack, and WorkPack supplies staff to a number of mining companies, some 6,000 back in 2018, some 6,000 odd workers. So it's not a small size agency by any means in terms of its workforce. But over the period of 28th July 2014 until 9th of April 2018 was the period that the contract actually existed. And over that period, there were 6 different contracts that were made between Mr. Rosato and WorkPack. And WorkPack, the employer in this case, had treated each employment as a casual employment of Mr. Rosato during this time. On the 2nd of October 2018, so this is going back 2 years now, Mr. Rosato, almost 2 years, Mr. Rosato wrote to WorkPack claiming that effectively, contrary to WorkPack's treatment of him, he had not actually been a casual employee. His claim relied on another court case, which was the scheme case, which, strangely enough, also involved WorkPack as well too. He claimed an outstanding entitlement to paid annual leave, paid personal and carers leave, and paid compensation leave, and public holiday pay entitlements that are due under the Fair Work Act. And he also made reference to an enterprise agreement known as the industry enterprise agreement involving WorkPack mining agreement as well. So Mr. Rosato claimed that throughout the whole of the approximately 3.5 years of what he saw as continuous employment by WorkPack did not pay him, and he did not receive any paid annual leave, any paid personal or carers leave, or any paid compassionate leave, or payment for any Christmas days, Boxing Days, or New Year's days, which were not actually worked by him over the Christmas shutdown periods. So you can actually see the status of this claim is just far and broad reaching of what was actually made. Now, what came out of this was that it was accepted that by the full case that it was correctly determined that casual employee is an employee who has no firm advance commitment from their employer to continuing an indefinite work agreed to by an agreed pattern of work. And Mr. Rosado actually relied on what's called the firm advance commitment rule coming out of this particular previous case. And so when we look at this, we go, okay, if there's no firm advance commitment, then it is defined as a casual worker. But if there is firm advance commitment, then effectively a casual worker is entitled to all of these annual leave loadings and annual entitlements, not annual leave loading, annual entitlements that come out of this. So when you look at how does this apply to your agency, let's have a look at what this case does. So effectively, it redefines what the meaning of a casual employee is. So now, part of that was that when we looked at this, the first argument around this at one level was that WorkPac essentially contested that Mr. Rosado was a casual employee because it was a question of contract that was specifically referenced to express terms in the contract that said this person is a casual employee. Now, on the other hand, Mr. Rosado turned around and said the contract is one part, but actually what he contested was that he was not a casual employee, and it's based on the question of all of the features of his employment which serve to identify its type of engagement that he had with the employee. So he actually said, look, it's not just about the contract, it's about my relationship with the employer. And so the court held that, again, it's about this firm advance commitment that needs to be assessed. Now, when we look at this for your agency, it's around the employment relationship will be found in the instrument which created and governs that relationship, which is one part, which is the contract. But what we also need to look at now is the employment is dynamic, which the court held, and it involves a high degree of interaction between the parties to that relationship. And what we're looking at here is the course of dealings between the relationship, the defining of the relationships and its indicators, and it's not just about the written terms of contracts, which are needing to be relevant. Now, if we take this apart, what this means is that what the court said, okay, let's start at the contractual relationship. And this is what we say, look at your agency contractual relationship to start with. Now, for the purposes of assessment about to be taken, this is what the court said, it is necessary to make some further observations about the nature of a firm advance commitment, which suggests it's either absent or present in an employment agreement. If the assessment is to be conducted as a question of contract, it must follow that a firm advance commitment must be promissory and must be a promise rather than just a contractual term. So with it, one of the areas we're going to look at and suggest is that there's a variation around the contracts to actually state that there is no firm advance commitment in your contractual positions that you have with any casual workforce, and effectively injecting this particular clause into the contracts that you have, or alternate, and actually your policy positions that you have as well is something to also look at. So one of the recommendations that you will see that we will have is the requirement to actually look at both your contracts and your policies that you in fact have to make them consistent around the specific no firm advance commitment for your casual workers. And this is really about clarifying their roles as well. The other part which the court looked at is looking at your agency and how it defines work roles. And so as part of that, we rely on the previous scheme case, but also this particular federal court case. Now, when they looked at, as I mentioned, they looked at the contract, but they also then looked at, well, what is the relationship that your agency has? And a firm advance commitment is likely to be absent where what the full court described as the usual manifestations of an absence of a firm advance commitment. So it's a bit of a circular argument that the federal court had. But effectively what they're looking at is namely irregular work patterns, uncertainty, discontinuity, and intermittency of work and its unpredictable nature as well too. So part of this is that what we're looking at is having also adjusting your policies to look at defining casual work in this particular way. There are ways that we can structure it around looking at irregular work patterns, rostering, you know, whether there's intermittency at going to broader group, all this sort of thing we can look at as part of your operational plans. But the main indicator around this is irregular work patterns, uncertainty, discontinuity, and intermittency of work and the unpredictability of its nature as well. The other indicator is the absence of a firm advance commitment is the existence of an employee who stands and waits. And this is what the court said. Or in other words, is only given the opportunity to provide his or her service in response to a specific demand. So as part of this, approaching staff with a view of a specific demand around specifically these areas, it may well be that you are looking at a set period of time. You can still define this, but it does provide some grey and uncertainty in how it is actually managed. What we are looking at in this session is framing this for your agency around what you need to do, what it is defined as under the federal court's decision, and how you can provide both security to using casual workforce without having a significant legal mitigation issue arising, an economic issue arising out of this as well. So what should you do as part of this? Well, really what you should do is identify all casual contracts really from your agency, and also focus on policies that you might have, and what we're asking yourselves to do is look at reviewing these casual contracts as well. Are they effective? And you can do this by reviewing the timesheets and periods that they have worked. Are they independent contractors, i.e. do they have an ABN number as well too that you've provided to them, or are they casual workers? Now out of this, is there or could there be a firm advanced commitment as we have defined within these slides that has come from the federal court? Within this, you are looking for those regular work periods. What is the engagement that your agency has had? You may need to go back a number of years around this as well too. And as part of that, you are looking at if there are any potential liabilities based on this current legal position and quantifying it. You may also, as we've said, raise this report with the executive management and board as well too, because it can be and could be quite significant. And also looking at what we are suggesting in the meantime is also looking at reviewing your contracts, your policies on this, and timesheet clauses to actually place in some of the federal court specific requirements if it is around specific casual workforce. We have already been approached around this, so if you do have any questions, you can contact our law firm on this. All of you have my direct mobile number, and more than happy for yourselves to contact me directly should you require assistance on this matter. We are expecting that there will be pending announcements by the federal government, the Minister for Industrial Relations on this in terms of whether there will be an amendment to the Fair Work Act to clarify this position. That seems to be the most likely next step. But in saying that, there is also another case that's potentially pending that will provide some further guidance on this as well too. Until that either of those effectively eventuates, we are working on this current legal position coming from the Federal Court, and it is something that your agencies do need to carefully consider. We will be circulating this webinar and supporting materials as long as together with the court case, the federal court case, for your reference, if you do like to have a look at that, and you will receive those resources this afternoon. We will open up the phone lines and computer lines to answer any questions that people might have. As always, while we are doing that, if you do have any questions after this session, by all means, please contact us on 1300 360 360 or email us at support@gemba360.com.